All please rise. The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the Philippines. Hear ye, hear ye, hear ye. All persons having business before the Honorable Supreme Court of the Philippines shall give their attention, for the court is now in session.
Please be seated.
Madam Clerk of Court, please to call the cases before us.
Good afternoon, Your Honor. Scheduled for this afternoon's oral arguments are the consolidated petitions in GR number 261123, duty to energize the Republic through the enlightenment of the youth, Duterte Youth Party List, represented by Chairperson Ronald Gian L. Cardema and Representative Ducielle Marie S. Cardema, Petitioner, versus Commission on Elections, House of Representatives, and Komunidad ng Pamilya, Pasyente, at Persons with Disabilities, P3PWD Party List, and its nominees led by Maria Rowena, Amelia v. Guanzon, Respondents. And GR number 261876, Duterte Youth Party List, represented by Chairperson Ronald Giancarlo L. Cardema and Representative Ducielle Marie S. Cardema, Petitioner, versus Maria Rowena Amelia v. Guanzon, Respondent.
Councils, please enter your appearances, starting with the petitioners.
Good afternoon, Your Honors. I am Ferdinand Topacio, respectfully appearing as lead counsel for the petitioners, with attorneys Edward Jalogo, Natalie Irene M. Velasquez, and Darlene Lou E. Pagunsan as my co-counsels. I also wish to respectfully manifest, Your Honors, that the representatives of Duterte Youth, namely Undersecretary Ronald Cardema and Ducielle Cardema, are present, although we wish to also additionally manifest that the incumbent representative of Duterte Youth for this current Congress is Representative Drixie Cardema, Your Honor. Thank you.
Good afternoon, Your Honors. Appearing for Respondents Commission on Elections and the House of Representatives in GR number 261123. I am Solicitor General Menardo Guevara, and together with me are Assistant Solicitor General Bernard Hernandez, Assistant Solicitor General Maria Victoria Sardillo Salong, Associate Solicitor Mary Rose Belay Ernesto. With the permission of the Honorable Court, I have designated Assistant Solicitor General Maria Victoria Sardillo Salong to deliver the opening statement on behalf of the Office of the Solicitor General and to address any and all questions during the interpellation. For the convenient reference of the Honorable Court, especially with respect to the timelines, the OSG will do a brief audiovisual presentation to be handled by State Solicitor Rowena as part of the opening statement. Finally, Your Honors, COMELEC Chairperson George Erwin Garcia and Commissioners Ernesto Ferdinand Macedo Jr. and Nelson Celis are also in attendance to act as resource persons if needed by the court. We are ready, Your Honor.
Good afternoon, Your Honors. Respectfully appearing for private respondents, Komunidad ng Pamilya, Pasyente at Persons with Disabilities Party List, or P3PWD for brevity, And for Ms. Maria Rowena Amelia B. Guanzon, attorneys Christian Robert S. Lim and attorney Catherine May de Besa Lau. We are ready. Further, Your Honor, we wish to manifest that in compliance with the advisory, Ms. Maria Amelia Guanzon is present, Your Honor. We are ready, Your Honor.
As discussed during the preliminary conference on October 3, 2023, and as stated in the advisory revised on November 6, 2023, each party through their respective counsels shall have a total of 25 minutes to make their respective opening statements. For the respondents, the time allotted shall be divided as follows: 15 minutes for the Solicitor General and 10 minutes for the private respondents. Presentation of audiovisual materials, if any, shall be included in the 25-minute allotted time. Interpellations of the members of the court shall immediately proceed after the parties' opening statements. The time allotted for counsel shall be exclusive of the time devoted to the interpellations by the members of the court. Counsel for petitioners may now proceed with this presentation.
Your Honors, please, for purposes of discussing the procedural issues, we have designated Attorney Edward Jalogo, who will consume 12 minutes of the 25 minutes allotted for the said issues, Your Honor. Thank you.
Your Honors, may it please this honorable court, on the procedural issues, we submit the following. Number one, the assailed COMELEC minute resolutions were issued in the exercise of COMELEC's quasi-judicial function. The substitution of P3PWD's nominees started as an administrative matter. However, it became a quasi-judicial matter when Petitioner Duterte Youth Party List filed a verified opposition thereto. In the case of Georgidi Agabao versus COMELEC, this court held that a matter falling under the administrative function of COMELEC may later on fall under its quasi-judicial functions. In the said Agabao case, two candidates for mayor of Santiago City, Isabela, namely Navarro and Aizon, submitted their respective certificates of candidacies with attached certificates of nomination and acceptance from the same political party, which is Partido Reforma. Both CONAs are for the position of mayor of Santiago City, Isabela. Both CONAs are also signed by Senator Panfilo Lacson as chairman of the party. As a result, both candidates were considered by COMELEC as independent candidates. Later on, Senator Lacson informed the COMELEC that his party did not issue a CONA in favor of Aizon. According to this court, when the COMELEC receives and acknowledges receipt of COCs and CONA filed in due form, it performed the administrative function of enforcement and administration of all laws and regulations pertaining to the conduct of an election. But following the acceptance of Aizon's COC and CONA, supervening events took place which necessarily called for the COMELEC's exercise of its discretionary power vis-a-vis the performance of its quasi-judicial functions. That is when Senator Lacson disclaimed the CONA allegedly issued to Partido Reforma to Aizon. And he sought the COMELEC's immediate action and requested that the necessary corrections be made in the certified list of candidates. In fine, Senator Lacson was seeking a resolution of a controversy which affected the candidacy of Aizon and Navarro and subsequently Agabao. The court continued in saying that in this regard, where the situation calls for the power of the COMELEC to exercise its judgment or discretion involving a determination of fact or resolution of controversies where parties adduce evidence in support of their contentions, the COMELEC ought to perform its quasi-judicial functions. Following the doctrine in Agabao, the COMELEC issued Resolution 10878 in the matter of jurisdiction on the accreditation and registration of citizens' arms, political parties, and party list groups and organizations, amending Resolution number 9366 and the COMELEC Rules of Procedure. With Resolution 10878, the registration of political parties and party list groups are now generally heard and decided by the COMELEC and Bank. The seventh whereas of COMELEC Resolution number 10878 states, whereas considering the pronouncements in the case of Georgidi Agabao versus COMELEC, therefore the accreditation and registration of citizens' arms, political parties and party list groups and organization fall under the administrative function of the Commission, unless an opposition is filed thereto, in which case it shall fall under the quasi-judicial function of the Commission. In this case, Your Honors, since a verified opposition to the substitution was filed by Petitioner Duterte Youth Party List against the substitution of P3 PWD nominees, the assailed minute resolutions should be considered as having been issued by the COMELEC in the exercise of its quasi-judicial function. Secondly, petition for certiorari under Rule 64 in relation to Rule 65 of the Rules of Court is the proper remedy from the assailed resolutions. The assailed minute resolutions of COMELEC and Bank approved the substitution of P3 PWD nominees in just 1 day from the time it was filed. It was approved despite the fact that the substitution was done after the deadline fixed in COMELEC's own resolution number 966 as amended by resolution number 10690. It was approved without the requisite publication, and the substitution was approved by 3 commissioners only in violation of the Constitution, which provides that the COMELEC and Bank should decide on all matters before it by majority votes of all its members. Thus, the assailed resolutions were issued by the COMELEC with grave abuse of discretion. As discussed above, the assailed minute resolutions were issued by the COMELEC and Bank in the exercise of its quasi-judicial functions. They are considered as final order or decision of the COMELEC and Bank on the validity of substitution of respondent PT PWD nominees. Therefore, a petition for certiorari under Rule 64 in relation to Rule 65 of the Rules of Court is the proper remedy from the assailed minute resolutions. Number 3, Duterte Youth Party List, Ronald Cardema and Ducielle Cardema have the legal standing to question the substitution of P3 PWD nominees. In the case of the province of North Cotabato versus Government of the Republic of the Philippines Peace Panel, this court held that when the issue concerns a public right, it is sufficient that the petitioner is a citizen and has an interest in the execution of the laws. In Lockett Jr. versus COMELEC, this court held, although the people vote for the party list organization itself in a party list system of election, not for the individual nominees, they still have the right to know who the nominees of a particular party list organizations are. The publication of the list of the party list nominees in the newspaper of general circulation serves that right of the people, enabling the voters to make intelligent and informed choices. In contrast, allowing the party list organization to change its nominees through withdrawal of their nominations or to alter the order of nominations after the submission of the list of nominees circumvents the voters' demand for transparency. Similarly, in COCOFED, Philippine Coconut Producers Federation Inc. versus COMELEC, this honorable court held that, most importantly, the required publication satisfies the people's constitutional right to information on matters of public concern. The need for submission of the complete list required by law becomes all the more important in a party list election to appraise the electorate of the individuals behind the party they are voting for. If only to give meaning to the right of the people to elect their representatives on the basis of an informed judgment, then the party list group must submit a complete list of 5 nominees because the identity of these 5 nominees carries critical bearing on the electorate's choice. A post-election completion of the list of nominees defeats this constitutional purpose. In view thereof, the issue in this case, which is whether a winning party list group can change all its nominees after the election, is an issue that concerns a public right. That is the right to information on matters of public concern. Hence, as held in the province of North Cotabato versus Government of the Republic of the Philippines Peace Panel, it is sufficient that the petitioners are citizens and have an interest in the execution of the laws. Aside from being citizens, both Ronald Cardema and Ducielle Cardema are public officials at the time of the filing of the instant petition. Ronald Cardema was the chairman of the National Youth Commission, while Ducielle Cardema was a member of the House of Representatives and vice chairperson of the Committee on Suffrage and Electoral Reforms. The jurisdiction of Committee on Suffrage and Electoral Reforms covers all matters directly and principally relating to the protection and advancement of the right of suffrage and conduct of elections, plebiscites, initiatives, recalls, and referenda. In this regard, both Ronald Cardema and Ducielle Cardema are interested in the faithful execution of election laws. Moreover, one of the assailed COMELEC resolutions, Minute Resolution number 22-0810, denied the verified opposition filed by Petitioner Duterte Youth. Being the party against whom an adverse final order decision was rendered by COMELEC, Duterte Youth is the proper party to elevate the said denial to this honorable court. Lastly, the jurisdiction over this case remained with COMELEC and now with this honorable court. It was not acquired by the House of Representatives Electoral Tribunal. Our jurisprudence is clear that the jurisdiction of House of Representatives Electoral Tribunal is limited only to members of the House of Representatives. To become a member of the House of Representatives, 3 requisites must concur. First, there must be a valid proclamation. Second, there must be a proper oath. And third, there must be an assumption of office. We submit that it was impossible for Commissioner Guanzon to have assumed the office of member of the House of Representatives because this court issued a temporary restraining order or TRO on June 29, 2022. Aside from COMELEC, the TRO also enjoined the House of Representatives from allowing Guanzon and other substituting nominees to assume office during the pendency of this case. The TRO was received by the Office of the Solicitor General, the Council for COMELEC, and the House of Representatives on the same day, June 29, 2022. The fact that Commissioner Guanzon was able to file a bill with the House of Representatives on June 30, 2022 is of no moment. The House of Representatives was unauthorized to receive the said bill due to the existence of the TRO. Your Honors, for the substantive issues, it will be covered by Attorney Topacio. Thank you, Your Honors.
May it please this honorable court. Your Honors, may I respectfully invite you to imagine, if you may, the following scenario. A person wishes to become a member of the House of Representatives, but he knows that for a variety of reasons, he is unelectable as a district representative. So he thinks to himself, why not become a congressman under the party list system? But then he may not have a party list, or if the party list has him as the first nominee, he may not also be elected. So what does he do? He picks a party list with nominees that are popular and with a palatable advocacy, which he may not necessarily share. He then waits in ambush for it to win a seat. Then he insinuates himself into the party list by substituting for the first nominee after the electorate have made their pick. And voila, Just like that, he is a congressman. Your Honors, this is an evil that must be avoided. The hijacking, nay, the gaming of the party list system by unscrupulous individuals. And that is the reason why safeguards are in place to forestall this sort of fraud and imposition. First, Your Honors, the party list law itself says in Section 8, and I quote, "No change of names or alteration of the order of nominees shall be allowed after the same shall have been submitted to the COMELEC," unquote, "except in limited instances, and that the substitute's name, quote, shall be placed last in the list." Second, there is a requirement of wide publication. In the implementing rules for RA 7491, in this case Resolution 10690, there is a provision in Section 4 for publication in, to paraphrase the late Susan Roses, not one but two national newspapers of general circulation. The list of nominees originally submitted by the respective organizations within 15 days from the deadline of November 15, 2021. The reason for this is to give time to voters to know the nominees of the respective party list, to know their identities, their backgrounds, their achievements, their reputation, etc. Your Honors, this is as it should be. As succinctly stated in the case of COCOFED versus COMELEC, the submission of a complete list goes into the right of the voters to know and make intelligent and informed choices. And if I may go on with the said ponencia, quote, "Most importantly, the required publication satisfies the people's constitutional right for information on matters of public concern." The need for submission of the complete list required by law becomes all the more important in a party list election in order to apprise the electorate of the individuals behind the party list they are voting for. If only to give meaning to the right of the people to elect their representatives on the basis of an informed judgment, then the party list group must submit a complete list of 5 nominees because the identity of these 5 nominees carries critical bearing on the electorate's choice. A post-election completion of the list of nominees defeats this constitutional purpose, end of quote. Sadly, it is the intendment of the party list law and COMELEC rules that Respondent Guanzon seeks to subvert. How, Your Honors? First, her substitution as first nominee in lieu of the first batch of nominees was made far beyond the deadlines imposed by Resolution 10690, which Commissioner Guanzon herself signed. We respectfully beg to differ with the contention of Respondent that the said periods are, quote, directory, unquote, after the elections, wherein they cite Engle versus COMELEC. Respondent Guanzon may have overlooked the particular nuance in the said decision wherein this high tribunal said that what becomes directory after the elections are formal matters, and that as to material requirements, the same must remain mandatory. The clarification could not be any clearer, and I quote, "Quite recently, however, we warned against a blanket and unqualified reading and application of this ruling, as it may carry dangerous significance to the rule of law and the integrity of our elections. For one, such blanket/unqualified reading may provide a way around the law that effectively negates election requirements aimed at providing the electorate with the basic information for an informed choice about a candidate's eligibility and fitness for office. A mandatory and material election law requirement involves more than the will of the people in any given locality. We are faced as well with an assault on the will of the people of the Philippines as expressed in our laws, in a choice between provisions on material qualifications of elected officials on the one hand and the will of the electorate in the other. We believe and so hold that we cannot choose the electorate's will. The said doctrine, Your Honors, mutatis mutandis, applies to the instant case. Second, strange it is the final nominees resigned en masse, even after the first nominee clearly became entitled to a congressional seat. Stranger still is that the original first nominee, a certain Grace Yanesa, already took her oath of office right after the party list was proclaimed. While this is not the oath, contemplated by law, as has been made hornbook doctrine in a long line of cases, the latest of which are the very recent ones of Uy versus Comelec and Haloshos versus Haloshos, which were companion cases decided in August 28, 2023. In relation to the learned concurring opinion of Mr. Justice Joseph Lopez in the Buenafe case. Such an act strongly demonstrates that Yanesa at the time that was capable of assuming her seat. She was not incapacitated, and definitely she is not dead. Why all five resigned at the same time shows that there was an evident scheme, Your Honors, to make the first set of nominees merely placeholders for Respondent Guanzon and her cohorts, a brazen attempt to circumnavigate the safeguards of the law. Third, there is something very, very wrong about a person who takes the reins of a party list, thus benefiting financially and otherwise therefrom, whose registration as such party list was approved by the Comelec while she was a sitting commissioner. This is precisely the kind of situation that anti-graft and corrupt practices devoutly endeavors to prescribe. Section 3I says that it is a corrupt act for a public official to be, and I quote, indirectly or indirectly becoming interested for personal gain or material interest in any transaction or act requiring the approval of a board, panel, or group of which he is a member, and which exercises discretion in such approval, even if he votes against the same or does not participate in the action of the board, committee, panel, or group. To allow respondents to profit from what appears to be a violation of a penal law and another law, the Code of Ethics for Public Officials, would place a premium on criminal conduct. Fourth, for all indications, Respondent Guanzon does not appear to be a bona fide member of the party list she seeks to represent. It is of public knowledge that the said respondent during the 2022 campaign and right after her retirement was tirelessly on the stump for a presidential candidate and not for disabled persons. While touring nationwide, she was dancing vigorously to the song Paro Paro G, Your Honors. This, coupled with the fact of her extremely belated joining of the P3WD and her illicit substitution as first nominee, puts into much doubt her bona fides as a member of the party list she so desperately wishes to represent. Black's Law Dictionary defines bona fide as in or with good faith, honestly, openly, sincerely, without deceit or fraud, truly, actually, without simulation or pretense, without notice of fraud, real, actual, genuine, and not feigned. Fifth, lastly, Your Honors, but most importantly, the resolution approving the belated substitution of nominees is vitiated with the fatal vice of falling short of the standard required by the fundamental law. Article 9A, Section 7 thereof says, and I quote, each commission shall decide by a majority vote of all its members any case or matter brought before it within 60 days from the date of its submission for decision or resolution. In Australia versus Comelec, Your Honors, the said constitutional provision was construed by the High Court in this manner. Quote, the provision of the Constitution is clear that it should be the majority vote of all its members and not only those who participated and took part in the deliberations. Even former Constitutional Commissioner Father Joaquin Bernas questions the CUA ruling in light of Section 7, which says, quote, majority of all the members, unquote. He thus concludes that, quote, 3 is not the majority of 7, unquote. End of quote. In fine, Your Honors, in questioning the substitution of Respondent Guanzon and 4 others as nominees of P3WD, it is not our intention to deny their group of representation. But if they will be deprived thereof, Your Honors, it will not be due to us. It will not be due to this honorable court, but due to matters of their own doing. They had 5 perfectly fine nominees. One was already a congressman-elect. Yet, because of the desire of Respondent Guanzon to herself become congresswoman, they took legal shortcuts that violated the spirit that giveth life to the law. Petitioners as a party list, citizens, and as members of Congress cannot sit idly by while Respondent trifles with the law, hoping that, to paraphrase Velasco versus Comelec, election victory can become a magic formula to bypass election laws. To end with a quote from the same ponencia, quote, the balance was always tilted in favor of upholding and enforcing the law. To rule otherwise is to slowly gnaw at the rule of law. Thank you, Your Honors.
Good afternoon, Your Honors. A reasonable place for me to start, it seems, would be the 1987 Constitution, the basis for the party list system representation. The purpose is clear and unmistakable: to democratize political power by giving political parties a chance to win seats in the House of Representatives. Echoing the intent of the framers, the Ninth Congress set out to craft a piece of legislation that will provide for the registration of party list organizations, the qualifications of nominees, the process for allocating seats, and the manner of filling in vacancies, among others. This is the Party List System Act, or Republic Act number 7941. But more than that, this piece of legislation expressly granted COMELEC the power to promulgate the necessary rules and regulations to carry out the purpose of the party list system. Honorable members of this court, I humbly implore you to bear this in mind. As the OSG, Council of Public Respondent COMELEC, maintains that these minute resolutions are not tainted with grave abuse of discretion, and so it must dismiss the petition. There are no questions as to the relevant facts. P3PWD's withdrawal and substitution of all its nominees came after the election, after its first nominee had already been proclaimed and had taken her oath of office. Being entitled to one seat, but without a nominee, P3PWD informed COMELEC's law department of its intention to substitute those who withdrew. Private Respondent Guanzon's name is in the new set of nominees provided by P3PWD. Satisfied that P3PWD's submissions met all the requirements, the COMELEC Law Department recommended the approval of the withdrawal and substitution. In turn, finding this recommendation to be proper, meaning compliant and duly substantiated by the evidence on record, the COMELEC and Bank granted the withdrawal of P3PWD's nominees and gave due course to the new list, subject to its compliance with the publication requirement. This is the first of the 3-minute resolutions being assailed before the Honorable Court. Following these events, P3PWD obliged and complied and in due time manifested its compliance. This unfortunately coincided with Duterte Youth's filing of its verified opposition to P3PWD's withdrawal and substitution. On June 22, 2022, the COMELEC and Bank issued the 2 other assailed resolutions. The first took note of P3PWD's manifestation and considered the same as satisfactory compliance with its earlier directive. The second denied Duterte Youth's verified opposition for lack of merit. Regrettably, the denial of Duterte Youth's verified opposition could not have come sooner. Before the COMELEC and Bank could act on its verified opposition, Duterte Youth elevated the issue before the Honorable Court. Duterte Youth ascribes grave abuse of discretion on the COMELEC and Bank for the simple reason that its withdrawal and substitution was filed after the 2022 elections, way beyond the deadline provided in Resolution number 9366. Meanwhile, Private Respondent Guanzon has since been proclaimed and taken her oath. But on June 29, 2022, this Honorable Court issued a temporary restraining order preventing Private Respondent Guanzon from assuming office as a member of the House. Against this factual and legal backdrop, the sole controversy then before this honorable court turns on whether COMELEC and bank committed grave abuse of discretion in issuing the 3-minute resolutions. Mindful of the constitutional intent behind the party list system and the provisions of RA number 7941, the OSG submits that the COMELEC and bank did not. And by addressing the issues in the advisory, we hope to convince this honorable court of the merit of the OSG's position. On the first procedural issue, it is humbly submitted that Duterte youth does not have the personal and substantial interest to question the 3 COMELEC minute resolutions, treating as they do the twin request of P3PWD to inform COMELEC of the withdrawal of all its nominees and substitute them with a new set of nominees. Once more, I'll repeat, but only for context, the P3PWD's withdrawal and substitution came in light of its having bested other party list groups and earning one of the reserved seats in the House. Your Honors, Duterte youth has not shown that it has sustained or will sustain a direct injury if P3PWD's withdrawal and substitution were allowed to stand. The second and fourth issues being related, I shall address them jointly. It is the OSG's position that Rule 64 in relation to Rule 65 does not cover rulings of the COMELEC and bank in the exercise of its administrative powers. Your Honors, I cannot emphasize the following enough. The proceedings which led to the issuance of the 3-minute resolutions required only a determination of whether the requirements under Resolution number 9366 on withdrawal and substitution were met by P3PWD. It did not require COMELEC to exercise its adjudicatory or quasi-judicial powers. And as a matter of procedure, once satisfied of P3PWD's compliance, the COMELEC's law department was well within its authority to make a favorable recommendation. And on the basis of the record before it, the COMELEC and bank found no reason to deviate from such recommendation. Your Honors, the OSG humbly submits that under this set of facts, the minute resolutions were rendered by the COMELEC and bank in the exercise of its administrative powers, nothing more. Hence, on the third issue, the inescapable conclusion that must follow is that the COMELEC minute resolutions amount to a final determination of P3PWD's compliance with the requirements on substitution. This must follow, logically speaking, given that, as explained earlier, the proceedings for withdrawal and substitution merely required satisfactory compliance with Resolution number 9366. That said, Your Honors, the OSG submits that this does not foreclose the filing of a proper petition to specifically question the eligibility, for instance, of a nominee. On the fifth issue, it is humbly submitted that the COMELEC retained the authority to act on P3PWD's withdrawal and substitution. The HREP did not acquire jurisdiction for the following reasons. First, at the time of the filing of P3PWD's withdrawal and substitution, there was no member of the House of Representatives to speak of. Second, P3PWD's withdrawal and substitution is not, and I quote, a contest relating to the election, returns, and qualifications of a member of the House, end of quote. More than that, despite Private Respondent Guanzon's proclamation and oath-taking, her assumption of office was enjoined by this honorable court's TRO. So in the ultimate analysis, to this day, Private Respondent Guanzon is not considered a member of the House for purposes of HRET's jurisdiction. On the final procedural issue, it is humbly submitted that the petition is premature. Assuming that Duterte youth had the legal personality to file an opposition and that this was the contemplated remedy, it is submitted that its direct recourse to this honorable court, even before the COMELEC and bank could act on its verified opposition, shows the clear prematurity of the present petition. At any rate, it is humbly maintained that these minute resolutions approving P3PWD's withdrawal and substitution did not and does not foreclose Duterte Youth's proper and more appropriate remedy under Resolution number 9366. Indeed, perhaps Duterte Youth's chairman realized the flaw in filing a verified opposition, which is why on July 1, 2022, he filed a petition to deny due course to private respondents Guanzon's certificate of nomination. And so in this sense too, the petition before this honorable court must be deemed as premature. In the interest of time, I shall address the issue on whether COMELEC's minute resolutions were tainted with grave abuse of discretion, as well as the sub-issues under it jointly. Duterte Youth equates the actions of COMELEC and bank through the 3-minute resolutions as being tainted with grave abuse of discretion because it approved the withdrawal and substitution outside of the deadline set in Resolution number 9366. Humbly, Your Honors, the COMELEC and bank did not gravely abuse its discretion. COMELEC, by virtue of its powers under Section 2, Article 9C of the Constitution, the Omnibus Election Code, Republic Act number 8436, among others, was conferred the authority to fix the deadlines, periods, or dates in order to ensure accomplishment of the pre-election activities. This much is settled. These pre-election activities and deadlines are mandatory, nay, crucial to ensuring the conduct of a free, fair, and honest elections on the date set by the Constitution. However, the COMELEC rules, or in this case, Resolution number 9366, cannot also be allowed to override the substantive law, RA number 7941, and most especially the Constitution. Your Honors, Resolution number 9366 cannot be applied in a way that would deprive a duly proclaimed party list from having its nominee take his or her rightful seat in the House. That would be anathema to the intention of the framers when they institutionalized the party list system in the Constitution. And as this honorable court considers the constitutionality of the approval of these minute resolutions, I humbly ask that this honorable court takes judicial notice of the retirement of 3 COMELEC commissioners at that time, which left COMELEC with only 4 commissioners, 3 months before the 2022 elections. Your Honors, the Constitution expressly allows and gives COMELEC the discretion to sit and bank or in 2 divisions. 2, COMELEC was granted the authority to promulgate its rules of procedure. It was pursuant to such authority that under its rules, COMELEC, when sitting and bank, only requires 4 members of the commission to constitute quorum for the purpose of transacting business. Further, it provides, and I quote, "The concurrence of a majority of the members of the commission shall be necessary for the pronouncement of a decision or resolution." These are our legal basis for insisting that the minute resolutions are not void. On another point, that all nominees of P3PWD barely 2 weeks before noon of June 30 opted to withdraw is certainly unfortunate, but it did happen. Unfortunately, too, for COMELEC, it does not possess any power under RA 7941 to compel the same nominees to continue as such. However, COMELEC under Section 16 is allowed to receive, by way of substitution, additional nominees in order to fill in the de facto vacancy. Your Honors, the sealed minute resolutions did exactly that. On the second substantive issue and its sub-issues, the OSG maintains that Section 9, which provides for the qualifications of party list nominees, must be complied with by all nominees, substitute or otherwise. However, COMELEC's authority to inquire into the qualifications must be through either a petition to deny due course or to cancel the certification of nomination, or alternatively, through a petition for disqualification. Legally, COMELEC cannot, in a withdrawal and substitution, inquire into substitute nominees' compliance. The most that COMELEC was legally allowed to do at that point was to ascertain, for instance, that the nominee was nominated only in one list. Finally, Your Honors, in addressing the last substantive issue, the OSG was simply guided by the 2015 revised rules of the HREP, as well as the internal rules of the 19th Congress. For the sole purpose of determining jurisdiction of the HREP, Rule 15 simply refers to a proper oath. This position is further bolstered by the internal rules of the 19th Congress, which describes the oath of office administered by the Speaker as a mere, and I quote, ceremonial affirmation. Honorable members of this court, it has been my privilege to stand before you and address the issues in the advisory on behalf of the OSG. I thank you for your time and your patience.
May it please the Honorable Court. A plain reading of the petition filed in GR number 261123 would show that there is no real substantive issue foisted by petitioners in opposing the substitution of the nominees of P3PWD. It bears emphasis that the petitioners are not questioning the qualifications of the nominees or the right of P3PWD to substitute its nominees. Petitioners are also not assailing the proclamation by the COMELEC that P3PWD is entitled to a seat of Congress. The only issue raised by the petitioners is the absoluteness of the November 15, 2021 deadline for substitution of nominees set by resolution number 10690. In other words, everything is just smoke and mirrors. First, this is not a novel question. In fact, the very issue of substitution of nominees of a party list group post-elections had already been resolved by the Honorable Court in the case of Angkos versus COMELEC, GR number 253805, November 3, 2020, where it ruled that there was no grave abuse of discretion on the part of the COMELEC in allowing petitioner Ducielle Cardema to replace her husband post-elections as representative of the Duterte Youth Party list in the 18th Congress. This COMELEC resolution, in the words of the Honorable Court, quote, appear to be in accord with the facts and applicable law and jurisprudence, close quote. Second, Section 8 of the Party List System Act clearly allows alteration of nominees even after the same has been submitted and approved by the COMELEC in cases of death, incapacity, or withdrawal of the nominees. Resolution number 10690 cannot be interpreted to subvert or even modify the clear and unambiguous wording of Section 8 of the Party List System Act. In the words of the Honorable Court, to Honorable Justice M. Lopez in the case of PDP Laban versus COMELEC, foremost verba legis non est rescindendum is the basic rule in statutory construction. The maxim translates, from the words of a statute, there should be no departure. Differently stated, a statute that is clear is not susceptible to interpretation and should be applied regardless of who may be affected, even if the law is harsh and onerous. The remedy is with Congress to modify or even abandon the law. Third, while the COMELEC is empowered to promulgate rules and regulations, these are mandatory only prior to elections. When sought to be enforced after elections, they are held to be merely directory, especially if they are held to be mandatory. Innocent voters will be deprived of their votes without any fault on their part. This was the ruling of the Honorable Court in the case of Engel versus Comelec. Furthermore, the petition is not without procedural defect. The assailed resolution numbers 22-0774 and 22-0798, hereinafter referred to as the assailed resolutions, which approved the withdrawal and substitution of nominees of P3 PWD, was an exercise of the Comelec's administrative and/or executive functions. In the case of Baitan versus Comelec, the Honorable Court found that the quasi-judicial powers of the Comelec pertain only to Section 2, Paragraph 2 of Article 9C of the Constitution. The Comelec's approval of substitute nominees is an incident of its function to register party list groups, which, according to the Honorable Court, in the case of COCOFED versus Comelec, involved the exercise of the Comelec's administrative power, particularly its power to enforce and administer all laws related to elections. The fact that petitioners assailed said resolutions through the use of Rule 64 of the Rules of Court has rendered the instant petition dead on arrival. As the Honorable Court ruled in Cherubin versus Comelec, Rule 64 does not cover rulings of the Comelec in the exercise of administrative power. In this connection, having been issued by the Comelec in the exercise of its administrative functions, the assailed resolutions cannot be declared infirm for the supposed failure to meet the prescribed form. In the case of Cagas versus Comelec, the Honorable Court mentioned and qualified Section 7 of Article 9A of the Constitution requiring 4 votes to only apply to final orders, rulings, and decisions of the Comelec rendered in the exercise of adjudicatory or quasi-judicial powers. As earlier established, the issuance of assailed resolutions are the exercise of administrative functions of the Comelec, not adjudicatory or quasi-judicial functions. Hence, the 4-vote requirement under Section 7 of the Constitution should not apply. What should apply is Comelec Resolution number 9936, which governs the enactment and promulgation of resolutions covering matters, issues, or concerns falling within the executive or administrative functions of the Comelec. Section 2, Paragraph 1 and 2 of that resolution provides a decision or resolution on an executive or administrative matter, issue, or concern shall be valid when the action is taken, approved, ratified, or confirmed or concurred in by a majority of all the members of the Commission present at a meeting at which there is a quorum. A quorum is determined by the presence of the majority of the members of the Commission with existing and valid appointments. In the instant case, on June 15 and 22 of 2022, the Comelec was composed only of 4 commissioners, namely Commissioner Socorro Inting, Marlon Casquejo, Aimee Ferolino, and Ray Bulay, who all attended the en banc session and voted upon the matter. Hence, 3 votes constituted a majority of all the members present at the meeting with quorum. Finally, all new nominees possess the requisite qualifications required under Article 6 of the Constitution and Section 9 of the Party List System Act. In fact, part of the documents scrutinized by the Comelec Law Department in its recommendation to the Commission en banc, which is extensively quoted in Resolution number 22-0774 on page 3 thereof as number 7, is an affidavit dated June 10, 2022 of Secretary General Donabel Tenorio and President Grace Llaneza, both of P3 to PWD, stating, quote unquote, the nominees, substitute nominees have all the qualifications and none of the disqualifications provided by law. Particularly, Respondent Guanzon is eligible as a nominee, notwithstanding the fact that she was a Comelec commissioner at the time the registration of P3 PWD was approved. For one, the approval of the registration of P3 PWD was by the 2nd Division of the Comelec, which she was never a part of during her tenure. Second, she became a nominee only on June 10, 2022, after she had long retired from the Commission on February 2, 2022. In fact, Section 3, Rule 4 of Comelec Resolution number 9366 allows nominees from appointive or elective offices to continue to hold office even after acceptance of their nomination, and the 1-year prohibition from being hired or rehired in a public office after the party list organizations fail to secure the needed votes to qualify them for a seat in the House of Representatives shall not apply to them. In closing, I am reminded of the words of Honorable Justice Lazaro Javier in the case of Ancla versus Comelec, wherein the Honorable Court said, Justice Mario Victor Marvic F. Lunan shared his enlightening thoughts during deliberation. It does not help Petitioner's position that petitioners asserted an alternative method of allocating party list seats only in the wake of their defeat in the 2019 elections, and that they never objected to the method currently in place when they benefited from and on the basis of it proclaimed winners in previous elections. An electoral system is meant to be an objective and dispassionate means for determining winners in an election. For it to be upheld at one instance and assailed at another based on how one fares is to undermine the electoral system's requisite neutrality and to subvert meaningful democratic representation. The judicial process is sacred and is meant to protect only those who are innocent. It would certainly leave an indelible mark in the conscience to allow a party to challenge a doctrine after it has ceased to be beneficial to it. Your Honors, it has been 1 year, 4 months, and 14 days since P3-PWD has been divested of its seat in the House of Representatives. 1 year, 4 months, and 14 days since the blind, hearing impaired, persons with disabilities, the sick, and poor families have been deprived of their voice in Congress, of hope for an inclusive education, access to basic needs, broader work opportunities, and freedom from various forms of discrimination. 391,174 people came out on May 9, 2022, and shaded P3-PWD on their ballots, reposing their trust and confidence upon P3-PWD to pass legislation for the welfare, rights, and interests of its constituents. I humbly implore the Honorable Court not to be misled by herein petitioners who have cried foul after benefiting from the very ruling of the Honorable Court in Angkos versus Comelec, a ruling which petitioners now seek to be reversed at the expense of 391,174 votes for P3-PWD. I humbly implore this Honorable Court to uphold its ruling that the judicial process is sacred and protects the innocent, protects the proportional representation of the blind, the hearing impaired, persons with disabilities, the sick, and poor families in Congress. Thank you, Your Honors.
Justice Rosario will make his interpellations.
Mr. Chief, good afternoon, ladies and gentlemen. Most, if not all, of my fellow justices have earlier expressed their intention or inclination to conduct an interpellation in order to clarify certain issues raised by the parties for the court's determination. I have been given the privilege of having the first crack in the long line of my colleagues wishing to interpolate on the matters and issues involved in this case. To make for an orderly proceedings, however, and to save time and give my give the other members ample opportunity to further their inquiry, I am limiting myself to some written questions which I have prepared and which involve more or less issues I consider to be the crux of the matter. I am quite certain that in addressing these issues, I'll be able to arrive at a just, disinterested, and judicious evaluation of this case. May I request the Comelec represented by Gian to please respond to my questions.
Good afternoon, Your Honor.
Hi, good afternoon. Before I proceed to my questions, Attorney, I'd like to make a few preliminary statements. If that's okay.
Yes, Your Honor.
The Constitution declares that open quotation, each commission shall decide by a majority vote of all its members any case or matter brought before it. Now, there are at least 4 cases which have interpreted this provision. In particular, the praise by a majority of all its members. COA versus COMELEC in 1987, Estrella versus COMELEC in 2004, Marcoleta versus COMELEC in 2009, and of course the case of Sibilia, 2013. Are you familiar with these cases, Attorney?
Yes, Your Honor.
Okay, I'm glad to hear that. In the case of COA, there were 6 incumbent commissioners, right?
Yes, Your Honor.
Of the 6, only 5 participated in the deliberations on a matter. In fact, 3 voted in favor, 2 voted against. The court held that 3 constituted a majority of the 5 members who deliberated and voted their own, en banc. And their decision is also valid under the Constitution. Now, in the case of Australia, unlike COA, the COMELEC was complete. There were 7 sitting commissioners. Like in COA, 5 participated in the deliberations on the matter. 3 voted in favor, 1 dissented, and 1 vote was not counted. Instead of following COA and declaring 3 as a majority of 5, the court abandoned the doctrine in COA and declared that majority means 4. So even if you have only 5 incumbent commissioners, you still need the vote of 4 and not of 3. Okay? This doctrine was in fact reaffirmed in the later cases of Marcoleta and Sibilia. Now comes this case of Duterte Youth Party List versus COMELEC. The question is whether we will continue to apply the prevailing doctrine in Australia or revert to COA doctrine or do something else.
Your Honor,
I'm not yet done, Attorney. I'm about to conclude my preliminary statement. Just be patient, Madam. Actually, we have prepared a table showing all possible scenarios in terms of the number of incumbent and participating commissioners and the probabilities of petitioner winning depending on which doctrine is applied. Assuming that the probability of each commissioner voting in favor of or against is 50-50, that is aside. So we can objectively determine to what extent the application of one doctrine or the other affects the parties' respective chances of prevailing by using so-called binomial probability. I will continue. Now, in an ideal situation, all vacancies in the COMELEC are filled and there are 7 sitting commissioners. Applying Australia, if there are 7, each party has a 50-50 or equal chance of winning because the basis is always 7 regardless of the number of participating commissioners. Each party needs 4 votes to prevail. However, when you only have 6, 5, or 4 incumbent commissioners, as in this case, the case of Duterte. The probability diverges because now petitioner needs more and more votes compared to oppositor or protestee. Thus, the advantage of the oppositor increases as the number of incumbent commissioners decreases because the majority remains constant at 4. You're following? Is it following? Okay, good. The probabilities in COA are fairer. This is my observation. But applying COA would mean arguing that the Constitution refers to participating commissioners when it says all its members. If the court interprets the phrase all its members to mean incumbent members, the probabilities are even fairer than when applying COA. And it could reasonably be argued, that the framers did not intend to include vacancies in that phrase. Now, this is my question. Is it your position, DOJ ka, ano? Ano?
OSG,
Oh,
Your
OSG.
Honor.
Yes. That the phrase all its members refers in this case to the 4 incumbent or sitting members of the commission. Do you agree?
I agree, Your Honor, that the provision as it reads only requires the majority
Okay.
of all its members.
Okay, that's good. So for you, that means that majority or 50% plus 1 of 4 is 3.
Yes, Your Honor.
And you are aware of this court's ruling in Estrella, Marcoleta, and Sevilla that the word all refers to 7 members, whether incumbent or not. Do you agree with that?
Yes, Your Honor, although
Why is that?
if I may be allowed to
Go ahead.
qualify my answer, my reading of those cases cited by this, by Your Honor, leads me to believe that those cases are not on all fours with the facts in this case. As far as Estrella, Cuba, and I think even the case of Mendoza, Your Honor, is concerned, these cases were decided on the basis of COMELEC's exercise of its quasi-judicial powers,
Which means
which, and Your Honor, this goes to my point that as far as the provision in the Constitution is concerned, the first sentence, which Your Honor actually referred to, specifically requiring a majority of all members, is the first sentence of Section 7, which was followed actually on the last sentence by decisions, orders of the commission shall be, and so on and so forth. Your Honor, in those cases, that sentence was in the context of the COMELEC's exercise of its quasi-judicial powers, which is why, humbly, Your Honor, I maintain that those cases are not on all fours with the facts herein. Rather, I would invoke the COMELEC Rules of Procedure as well as COMELEC Resolution number 9936 issued in 2015, which treats of the conduct of business of COMELEC and bank in the exercise of its administrative powers.
of course, you're not saying that we should revert to the case of COA versus COMELEC.
No, Your Honor.
But in COA, as you may have noted earlier, the Supreme Court held that 3 is a majority of the 5 members who deliberated and voted. Does the Constitution say majority vote of all its members who deliberated and voted? Attorney?
Your Honor, if my recollection serves me right, it does not. There is no qualification.
So the Constitution does not say that.
It does not, Your Honor.
In fact, as said in Australia, had the framers of the Constitution intended that it should be the majority of the members who participated or deliberated, it would have clearly phrased in that way, as it did with respect to the Supreme Court in Section 442, Article 8. Do you agree, Attorney?
Yes, Your Honor.
Do you think the phrase all its members could be interpreted to mean incumbent or sitting members only?
Your Honor, without further qualification, I believe that that sentence should be interpreted plainly.
You agree?
Yes, Your Honor.
Now, let's go to the Comelec rules of procedure. Rule 3, Section 5A provides quorum. Votes required. When sitting en banc, 4 members of the commission shall constitute a quorum for the purpose of transacting business. The concurrence of majority of the members of the commission shall be necessary for the pronouncement of a decision, resolution, order, or ruling. Why did the Comelec decide that quorum should be 4? If you know.
Your Honor, unfortunately, I am not aware of the wisdom behind the provision.
Maybe because 4 is a majority of 7. So since Comelec itself has set a quorum at 4, regardless of the number of incumbent commissioners, why should majority be less than 4? Should Comelec change the rule on quorum as well? In your opinion, Attorney?
Your Honor, perhaps if it would produce a possible vagueness, then it would not hurt for the Comelec rules to specify the number required. However, my reading, Your Honor, is that those provisions mentioned by Your Honor is clear enough.
Okay. This is just a would there be a violation of the right to suffrage, counsel, if a party list was duly elected, but there is no one sitting in the House of Representatives due to issues such as eligibility of a party list nominee?
Your Honor, it would frustrate the intent behind the party list system when the framers institutionalized party list system in the Constitution.
Still for Comelec, Comelec issued resolution number 106 validity quorum, a decision Now, quorum is defined in section 1, paragraph 2, same resolution. And valid appointments. So, is it your position that the assailed resolution were issued pursuant to COMELEC's administrative function?
Yes, Your Honor.
Oh, that's my last question. May I request the petitioner's counsel to please take the podium. It is now your turn, Attorney Ferdy Topacio, to clarify this representation on.
Thank you, Your Honor. I'm at this court's disposal.
My question will more or less dwell on the eligibility of your client, Ms. Guanzon, to be a party list nominee. Section 9, Attorney Topacio,
Yes, Your Honor.
states that no person shall be nominated as party list representative unless he is natural born citizen of the Philippines, a registered voter, a resident of the Philippines for a period of not less than 1 year immediately preceding the day of the election, able to read and write, and a bona fide member of the party. Take note of that. A bona fide member of the party or organization which he seeks to represent for at least how many days?
90 days, Your Honor.
90 days preceding the day of the election. And is at least 25 years of age on the day of the election. In case of a nominee of the youth sector, he must at least be 25 years, but not more than 20 years of age on the day of the election. Any youth sector representative who attains the age of 30 during his term shall be allowed to continue office until the expiration of his term. Now,
Yes,
this is
sir.
my question for Commissioner Guanzon. When did Attorney Guanzon become a bona fide member of P3PWD?
Your Honor, I think the best person to be in a position to answer that would be either Commissioner Guanzon herself or her counsel, Your Honor, former Commissioner Robert Christian Lim.
Do you think they could present documents to the court to prove this? The membership?
May I yield the rostrum to Attorney Lim, Your Honor?
If I may,
You
Your
want me to
Honor.
repeat the question, Counsel?
No need, Your Honor.
Okay lang, kailan
Ms.
to?
Guanzon became a bona fide member of P3PWT when she took her oath on February 4, 2022. We have a copy of the oath-taking oath administered on February 4, 2022.
How about the official date of her retirement?
Official date
As
of her
former
retirement
commissioner.
is under the Constitution, February 2, 2022.
That is the official date of retirement of Attorney Guanzon.
Yes, Your Honor.
In fact, I think this is a matter of public record. The retirement ceremony for former Commissioner Guanzon was held February 2, 2022. Correct.
I think it was 3, Your Honor, February 3. She retired on February 2, but I think the party was held on February 3, Your Honor.
I noted in my código that if her official retirement date was on or before this date, that's February 2.
Yes, Your Honor.
It is possible that she was a member of P3PWD 90 days preceding the day of the national and local elections on May 9. What year?
May 9, 2022. She took her oath, became a member on February 4, 2022. That's more than 90 days, Your Honor.
So okay siya ron sa
Yes,
90 days.
90 days before May 9 is February 8, Your Honor.
You know, I'm asking this question to help us clarify whether Commissioner Guanzon is qualified, diba? Or whether she was able to meet the requirements, particularly that she was a member of this, ano pangalan party list?
P3 PWD, Your Honor.
90 days preceding the election. And also, for us to find out whether she, as Attorney Topacio and his co-client persistently claim, has engaged in partisan political activity while sitting as an incumbent COMELEC commissioner.
Our position, Your Honor, is that we deny these malicious imputations, Your Honor, especially considering that Ms. Guanzon was not yet a member of the party
In the
during
same way,
her incumbency as commissioner.
in the same way that you are denying that Guanzon benefited from the approval of P3 PW's registration as a party list during her term as COMELEC commissioner.
Yes, Your Honor.
So in other words, when she became a member of this organization group, she has ceased to be a member of a commissioner of COMELEC,
Yes, Your Honor.
and yet she was able to meet the 90-day, prescribed.
Under the
Period.
Republic Act 7941, Your Honor.
I think that's my last question, Council.
Thank you, Your Honor.
I'll just try to go over by note. Again, where's the counsel for petitioner? On the matter of substitution, attorney, naguguluhan kasi ako rito eh. As they say, what is sauce for goose is sauce for gander. Your client, former Commissioner Guanzon, had dissented from approving the substitution of petition. I'm sorry, I got it mixed up. It should be the counsel for, and I have the same question for you. In paragraph 46 of Respondent COMELEC comment, COMELEC stated that it granted petitioners several applications for withdrawal with substitution of nominees even after the polls have closed. Okay. In minute resolution number 19-0849, dated August 28, 2019, 4 of your nominees, this is numbers 2 to 5, were substituted, and COMELEC approved this. Attorney Topacio.
Your Honor, please, before I respond to that, may I make a very respectful manifestation in my opening statement, Your Honor, which was furnished in advance to this honorable court. We never made any allegation that Respondent Guanzon engaged in partisan politics, Your Honor, while a member of COMELEC. In the main, Your Honor, please, if I may be allowed just 2 minutes, our main objection to her qualification, aside from the Anti-Graft and Corrupt Practices Act, is Republic Act 6713, Your Honor, which states in Section 7, prohibited acts and transactions, in addition, and I quote, in addition to acts and omissions of public officials and employees now prescribed in the Constitution and existing laws, the following shall constitute prohibited acts: and transactions of any public official and employee who are hereby declared to be unlawful. A, financial and material interest. Public officials and employees shall not directly or indirectly have any financial or material interest in any transaction requiring the approval of their office, unquote. And that this prohibition shall continue to apply for a period of 1 year after resignation, retirement, or separation from public office. XXX, Your
So
Honor.
there was no such statement or claim that was made by your client?
None, Your Honor.
Not even any insinuation?
No, we concede, Your Honor, that she fell within the 90-day rule, but is still within the 1-year prohibition of engaging in any financial or material interest in any transaction requiring the approval of her office. In this case, the COMELEC was the one that approved the registration of P3PWD, Your Honor, and the anti-graft law clearly states that even if she did not participate, even if she voted against, as long as she's part of that body, tribunal, or group, then that is a corrupt practice, aside from violation of 6713, Your Honor.
Okay. This representation stands corrected.
Just to clarify,
I recall having gone over this allegation in one of the pleadings filed at the instance, my recollection, at the instance of the petitioner.
Yes, Your Honor. At any rate, Your Honor, the opening statement is a matter of record. Thank you, Your Honor.
That's all. Thank you very much, Attorney Topacio.
We thank the Honorable Court.
One last question for Respondent Guanzon to counsel. Respondent Guanzon dissented from approving the substitution of Petitioner Duterte Youth. The Duterte Youth nominee in the 2000 elections. That was all in the news. Yet, now you are a substitute nominee, Guanzon. What makes her substitution here different from the Duterte Youth substitution of nominees during the 2019 elections?
If I may, Your Honor, there were 2 sets of substitution that occurred in the 2019 elections for the Duterte Youth. One set of substitution happened in March prior to elections. That was when Mr. Ronald Cardema wanted to become the #1 nominee. And that was when she dissented, I think based on 2 grounds. First, the issue of timelines, just beyond the deadline. And second, on the issue of Mr. Cardema being overage to represent a youth party list, which is under the Constitution required to be 25 to 30 years old. Now, the second one was after several proceedings and post-elections, Mr. Cardema withdrew the nominations as well as the other nominees. And instead, Ducielle Cardema came back after resigning as a nominee, came back as a nominee for the Duterte Youth as #1 nominee. If I may recall, Your Honor, although I'm not as privy to those facts in that 2019 case, I understand she had objections also, Ms. Guanzon, to the substitution by Ms. Ducielle Cardema. But unfortunately, the majority of the COMELEC already ruled that it was that substitution is allowed. In fact, I think in a vote of 4-6-1, Ms. Guanzon was not present during the en banc to vote for that. Voted to approve that substitution. Then second, Your Honor, in the case of Angkos, the Supreme Court sustained the COMELEC in that resolution. So it has become basically case law. And as a member of the bar, Ms. Guanzon has to follow the doctrines laid out by the Honorable Court.
In other words, counsel, the grounds upon which the substitution was anchored in the case of Commissioner Guanzon is quite different, or quite different from that of a petitioner.
Yes, Your Honor.
Okay, thank you.
Thank you.
That's all, CJ. Thank you very much. I finished. Thank you. Thank you.
Is Jeopardy Mampaw for his interpellation?
Thank you, Chief. I have a few questions for Petitioner Duterte Youth, Respondent P3PWD, and the Office of the Solicitor General. These questions will on, as agreed upon, on the procedural and substantive issues. May I request Attorney Dialogo, the one who presented the procedural issues, representing the Duterte Youth.
Good afternoon, Your Honor.
Does the Duterte Youth have the legal personality to impugn the approval of the substitution of P3WD party nominees?
Yes, Your Honor. As mentioned in my opening statement earlier, Your Honor, we cited the case of the province of North Cotabato versus the government of the Republic of the Philippines Peace Panel, wherein this honorable court held that when the issue concerns a public right, it is sufficient that the petitioner is a citizen that has the interest in the execution of the law, Your Honor.
As far as the Duterte Youth is concerned, what injury, direct or indirect, would you say you suffer from such substitution?
Your Honor, as discussed earlier, in 2021, meaning after the 2019 elections, the COMELEC amended its rules on substitution and issued COMELEC Resolution 10690, wherein the COMELEC put a stricter deadline on the substitution, specifically on substitution due to withdrawal. And for the first time, Your Honor, the COMELEC stated in its resolution that no substitution shall be valid after the said deadline. That was not stated in the 2019 rules, Your Honor. So in that case, Your Honor, all the party list organizations were of the impression that after the said deadline, no substitution could be made. No? So, however, P3PWD, after the deadline, applied for the substitution, Your Honor. So the injury, Your Honor, is in the sense that the playing field among the party list organization is no longer equal, Your Honor, because everybody was of the impression that the deadline is definite, yet petitioner responded, P3PWD suddenly substituted after the deadline, Your Honor.
Does that constitute direct or indirect injury on the Duterte Youth as a result of these?
We submit, Your Honor, that it's a direct injury, Your Honor, because Duterte Youth is a duly registered party list organization, Your Honor.
This means that if you wish to have your nominees substituted, P3PWD would likewise have the right to question or challenge or oppose such substitution.
Yes, Your Honor, if the substitution is invalid, like the case of what P3PW did, Your Honor.
You have two petitions you filed in this court. GR number 261-123 and GR number 261-876. You filed this petition under Rule 64 in relation to Rule 65 that governs the review of judgments, final orders or resolutions of a COMELEC and Commission on Audit. Still and all, Rule 65 applies only to petitions against any tribunal, board, or officer exercising judicial or quasi-judicial functions that has acted without or in excess of jurisdiction or with grave abuse of discretion amounting to lack or excess of jurisdiction. On this point, can you tell this court the three powers of Comelec as discussed in the case of Agawao versus Comelec 258, 456, your number 258, 456, promulgated on July 26, 2022, citing the 2009 case of Bidol versus Comelec?
Your Honor, the powers of the Comelec are administrative powers, quasi-judicial powers, and quasi-legislative power, Your Honor.
In your opening statement, it is your postulation that the Comelec, in this case, exercise quasi-judicial power.
Yes, Your Honor.
Why?
Because, Your Honor, as I pointed out earlier, Your Honor, the petitioner, Duterte Youth, filed a verified opposition in the Comelec against the application of PT-PWD for substitution. And as I mentioned earlier, this matter started as an administrative matter. However, when the opposition is filed, the Comelec will now be required to decide a legal controversy because of the opposition, and therefore the matter has become a quasi-judicial matter, Your Honor.
So do you disagree with the theory of the Office of the Solicitor General that it is an exercise of administrative function?
Definitely, Your Honor.
Given, as you have said, that it is an exercise of the quasi-judicial power of Comelec, what would have been the Comelec's course of action?
Your Honor, the Comelec course of action should have referred the matter to one of its division and heard the opposition, Your Honor.
Is there a jurisprudence to that effect? Does the Agawao versus Comelec make a jurisprudential ruling to that effect, that it should be referred to the Comelec division for hearing?
Your Honor, I can't remember the exact wordings in Agawao, Your Honor, but I understand that in the rules of Comelec, when a matter is...
You have not read a categorical pronouncement of the Supreme Court in the case of Agawao versus Comelec that the Comelec's course of action should have been to refer the case to a division for hearing?
In Agawao, Your Honor, there is a statement saying from this court that the Comelec should have referred the matter for hearing, Your Honor.
Are you sure of that?
Yes, Your Honor. In fact, Your Honor, as I also mentioned in my opening statement, because of the decision of this honorable court in the case of Agawao, the Comelec changed its rules on party list and political party registration such that before it was being heard and decided in division, but because of the Agawao versus Comelec decision, the Comelec adopted a resolution wherein the application for registration of political parties and party list groups are now being heard by the Commission and Bank. However, it is stated in the rules that if an opposition is filed, it shall be referred to a division because it will become a quasi-judicial matter and the hearing will be conducted by a division of the Comelec, Your Honor.
You must have read the Comelec rules of procedure. Can you point out a specific section there decreeing that it should be referred to the Comelec Division for hearing?
At the moment, Your Honor, I cannot do not have the exact section or provision in the Comelec rules, but I know that that is the rule in the Comelec as a practitioner that when the matter is a quasi-judicial matter, it is being heard first by the division, Your Honor.
You cannot remember the section, but you are sure there is such provision or rule in the Comelec Rules of Procedure to that effect.
Yes, Your Honor, because that is also being cited, in fact, by the public respondent in her comment, Your Honor, and her pleadings.
In the Agaba versus Comelec, did it mention about the Comelec Rules of Procedure relative to the referral of the case to Comelec Division for hearing?
I cannot remember, Your Honor, but what I vividly remember is that this honorable court mandated the Comelec that in this situation, even if it started as an administrative matter, when there is a legal controversy, it should be set for hearing, Your Honor.
Thank you. May I now ask, thank you.
Thank you,
May I
Your
now
Honor.
ask Attorney Topacio to answer these questions delving on substantive issues?
Thank you, Your Honor. I am at the court's disposal.
Having heard the case of Estrella versus Comelec, you must be familiar with the ruling of the court in that case in 2004
Yes, I am, Your Honor.
or 72 scrap 238. Okay, what is the ruling of the court in the case of Estrella versus Comelec in regard to the voting of the Comelec commissioners?
Your Honor, with respect to not only the Comelec but other constitutional commissions, it should be a majority vote of all its members, Your Honor.
How can you now relate the ruling of the court in Estrella versus Comelec to this case?
In
Let
this-
me use the word that you Latin press. Does the ruling of the court in Estrella versus Comelec apply mutatis mutandis to this case?
Yes, it does, Your Honor. As I have stated that the question resolutions fall short of the constitutional requirement of majority of all members, Your Honor.
Do you recall that in that case, there were 7 incumbent commissioners, but in this case, there were only 4 incumbent commissioners. So there is that
Yes, Your Honor, but the fundament, I'm sorry.
clear distinction.
Well, Your Honor, the fundamental charter did not make any distinction. And so it is my humble position, Your Honor, that the legal principle that ubi lex non distinguit nec nos distinguere debimos should apply, Your Honor.
So you cannot apply mutatis mutandis here.
I was saying mutatis mutandis, Your Honor, because Estrella was with respect to regular elections, not party list, Your Honor. That is what I meant.
That case discussed the voting of the 7 incumbent commissioners, and there is a stark difference here. In this case, there were only 4 incumbent commissioners.
Nonetheless, Your Honor, I believe the rule applies because in Australia, Your Honor, if I recall correctly, one even inhibited, Your Honor, Commissioner Ralph Lantion, and in fact, he was censured by the court because he wanted to inhibit only in the division but not in the bank, Your Honor. So I believe that nonetheless, the general rule applies because the Organic Act itself, Your Honor, did not distinguish.
What about the case? And this is the case which has not been mentioned here. Dumayas Jr. versus Comelec.
I apologize, Your Honor, I'm not familiar with the case.
409 is CRA 407. 2001 case, April 20, 2001. You have never read that case?
I'm sorry, Your Honor, I did not, I must admit, because my practice is not really election law, Your Honor.
In that case, there were 4 incumbent commissioners, 2 retired. Can you not apply mutatis mutandis, that ruling to this case? Because here there were likewise 4 incumbent commissioners.
Yes, Your Honor, in that case, it would be my humble position that the party would need a unanimous vote of all the incumbents in order to comply with the constitutional requirement, Your Honor.
The striking phrase in these proceedings is the constitutional provision, Article 9A, Section 7. Its provision shall decide by a majority of all its members any case or matter brought before it. Majority of all its members. The word majority, we learned this, has 2 kinds: absolute majority and relative majority.
Yes, Your Honor.
Now, how do you construe the word majority there? Is it absolute or relative majority?
Since there is no qualification, Your Honor, legal hermeneutics mandates that it be interpreted in its regular and common usage, which is a simple majority, Your Honor, or absolute majority.
Absolute.
Yes, Your Honor.
I say absolute or relative majority.
Absolute, Your Honor, meaning, if I may, 1/2 plus 1, Your Honor.
What about relative majority?
Yes, Your Honor, because as stated also by, as quoted by this honorable court in Australia, one of the framers of the Constitution himself, Father Joaquin Berna, said that 3 is not a majority of 7.
So, what is majority of 4?
A majority of 4 would be 3, Your Honor.
3.
But that is relative majority, Your Honor.
When we say absolute, shall we not consider the number of the commissioners, whether incumbent or retired?
I believe, Your Honor, and it is my humble opinion or position, that we should not, Your Honor, because the framers of the Constitution must have considered that possibility, because they must have taken the entirety of the 87 Constitution into consideration when they drafted this provision. And the Constitution, Your Honor, not only provides for appointments, but for the retirement, the terms of offices of the constitutional commissioners, Your Honor. And as is stated in Australia also, Your Honor, had the framers meant otherwise, they would have at least made reference to Section 4.2 of the Article 8 with respect to the judiciary, which mandates a different kind of majority for this honorable court to dispose of all matters and actions before it.
So it's your interpretation that the word majority under Article 9A, Section 7 should be construed to mean absolute majority.
Yes, Your Honor, as I believe it is this honorable high tribunal's interpretation also, Your Honor, in Australia and other cases.
It is apparent to us that in the past,
I'm sorry, Your Honor.
Duterte youth had similarly applied for withdrawal and substitution of its nominees beyond the deadline set for filing petitions for substitution due to withdrawal of candidates, and even after the closing of the polls, which applications were granted by the Comunidad. How is that different from the issue at hand?
Your Honor, with all due respect, I am not the lawyer of Duterte Youth in that case. I believe it is the Honorable Chairman of the Comelec, the Honorable George Garcia. He is present and may enlighten us. But from what I know, Your Honor, it was made before the deadline, Your Honor. And in fact, the substitutions, I hope that Chairman Garcia will correct me if I'm wrong, Your Honor. From what I know, the substitution suffered so many setbacks that they were forced to withdraw it and go on with the original nominees, Your Honor.
If such withdrawal and substitution were granted before, why would the court disallow now the withdrawal and substitution of P3PWD?
Your Honor, please, with all due respect to the Honorable Court, I may not be doing justice to my client by my narration of facts. Perhaps the court would like to consult with Chairman Garcia, Your Honor. My narration of facts may not be accurate, and I may be misleading the court inadvertently. So I beg the indulgence, if it is the pleasure of this honorable body, the council may be more familiar with the facts, Your Honor.
We will just note your manifestation.
Yes, Your Honor. I'm sorry. I may be misreciting certain facts. For that, I meant no disrespect and no intent to mislead the honorable court.
Plain reading of Section 8 of Republic Act 7941 does not seem to provide a deadline regarding the filing of substitutions of party list nominees. This being so, is Comelec Resolution 10690 fixing the deadline for withdrawal of nomination by not later than November 15, 2021 valid?
Your Honor, please, with all due respect, I believe that there is an express statement that deadlines may be set by the Comelec in the exercise of its rule-making powers, Your Honor. And I quote from Section 8 of 7941, which states, and I quote, "No change of names or alteration of the order of nominee shall be allowed after the same shall have been submitted to the Comelec, except in cases where the nominee dies or withdraws in writing his nomination, becomes incapacitated, in which case the names of the substitute nominee shall be placed last on the list." This provision, Your Honor, it is my humble view, leaves to the Commission on Elections the implementation of the intendment of the law. And I believe that the intendment of the law is that the substitution is the exception rather than the rule, because there is publication, and according to the cases which this representation has cited in its opening statement, it is of paramount importance for the informed decision of the electorate that they know the personalities that they are voting for in case they vote for a particular party list, Your Honor, because it is, of course, the reality that it is not a party list, which is an organization, but the representative thereof who sits in the House of Representatives, Your Honor.
Following the deadline set by Comelec Resolution 10690, your position is that Comelec could have disapproved P3PWD substitution of its nominees, correct?
Yes, Your Honor, for having been made beyond the two deadlines imposed by the resolution, Your Honor. I have it here.
Do you now advance the view that P3PWD is already barred from submitting a new set of nominees?
Yes, Your Honor, and also in view of the circumstances of this case, that such a submission, not only does it not fall outside of the deadlines, but it is not for any of the causes, Your Honor, which is death or incapacity, Your Honor. The reason why there are two deadlines, one for voluntary withdrawal, Your Honor, which is earlier, is that according to case law, when you make a voluntary withdrawal, you may have planned it, you have fully reflected on it, but death or incapacity is totally unplanned. So there is a longer deadline, Your Honor. In this case, the substitutions were made not because of any death or incapacity, as in fact, the original 5 nominees are very much alive, but for whatever reason, Your Honor. Another thing, Your Honor, if I may, is that a reading of the law, the case law, the resolutions of the COMELEC will reveal the intention that all 5 nominees should not be allowed to withdraw. And I will state the reason, Your Honor. It states that when there is a substitution, the substitute is placed last on the list of the nominees. I believe the reason for this is to deprive the party list of the choice of naming who the first nominee is, who will be the one to sit in Congress. And this is very evident in the Lock-in case, Your Honor, when there were 4 grounds for withdrawal: death, voluntary withdrawal, incapacity, and the withdrawal by the party list of the nomination of the nominee. The Supreme Court struck down the 4th ground because, according to them, it will place at the whim and caprice of the party list the nomination for first nominee, which the law does not deem to be desirable. Because
Having said that, what happens now to P3 PWD's rightful representation in the House of Representatives?
Your Honor, by withdrawing the 5 nominees beyond the deadline and without valid grounds or causes, then they, by their own acts and initiatives, they have forfeited their seat in the House of Representatives, Your Honor.
Since the personality involved in our party-list system is the party or organization itself, and the individuals are only indirect personalities, who does the electorate vote for?
Your Honor, as stated in ruling case law, the electorate votes for the party list, but with full and informed knowledge of who the personalities are, so that they may examine the capacity, the fitness for office, the reputation, the character of those representatives, because they will be the ones who shall sit in the House of Representatives, Your Honor.
A candidate's decision to run as an independent candidate or to join a political party, group of aggravation is left entirely to his or her discretion. If we disallow an individual from being a party list nominee, does this not run counter to the right of individuals to form an association as guaranteed by the Constitution?
Yes, Your Honor, but those rights must be exercised within the confines of the law, because no law is licensed, Your Honor, not even the party list law. The objectives of the party list law are laudable, Your Honor, and I believe in them. In fact, I represent a party list. I've represented some party lists, Your Honor, but always and in the final act, Your Honor, the law must be followed. Otherwise, as stated in one of the cases I've mentioned, we shall whittle away the force of the law. And as stated also in one of the cases that I have mentioned, electoral victory is not a magic wand to be waved about in order to justify taking shortcuts with the law.
Thank you, Attorney Topacio.
Thank you, Your Honor.
May I
We
ask
thank the court.
the lawyer for Respondent P3 PWD, Attorney Lim, to answer these few questions?
Yes, Your Honor.
You must be aware of the latest decision of the court last August 9, 2023 regarding the case of Roberto Oy Pinpin versus Halosmos.
I read it in the newspapers, Your Honor. But I have not read
What
the entire
have you
text,
read?
Your Honor. I have not. I just
Regarding
read
such ruling.
I understand that it was the
When
duty of the
does-
COMELEC to
When
proclaim.
does the House of Electoral Tribunal take cognizance of such case?
Upon a valid proclamation,
Okay.
upon a oath, and upon assumption of office, Your Honor.
Your client, former Commissioner Guanzon, has she taken his oath before the Speaker of the House of Representatives and in open session?
No, Your Honor.
Is she barred from performing her congressional duties?
The Honorable House of Representatives has obeyed the temporary restraining order of the Supreme Court. Hence, she cannot assume as congressman of for P3PWD.
So she has never discharged her congressional duties
Not yet, Your Honor. Officially.
because of the TRO we issued.
Yes, Your Honor.
Let's go to substantive issues. Section 8 of Republic Act 7941 allows the substitution of nominees of party lists when one, the nominee dies, two, when the nominee withdraws in writing his or her nomination, and three, when the nominee becomes incapacitated. Thus, party list nominees have the right to resign or withdraw their nomination. No one can force them to remain as nominees against their will. Nonetheless, can you enlighten us on the reasons underlying the resignation and withdrawal of all your 5 original nominees?
I would understand, Your Honor, that the first nominee that was supposed to sit in Congress resigned due to the fact that her daughter was already stage 3 cancer, Your Honor. And I have not inquired as to the other nominees, no? But that was the main reason why the number 1 nominee withdrew as the number 1 nominee. And I understand it was the party direction, the board of trustees that decided that they would be better off with Ms. Guanzon as the representative congressman in Congress to make more effect for the party, Your Honor.
All that the people vote for the party list organization itself in a party list system or election, not for the individual nominees. Don't you think that the electorate still has the right to know who the nominees of any particular party list organization are?
Yes, Your Honor, definitely. That is why the Honorable Commission on Elections required conditions sine qua that the P3PWD publish in 2 newspapers the new nominees, which the P3PWD complied with.
Don't you think that the act of changing nominees through withdrawal of nominations or altering the order thereof after submission of the final list of nominees circumvents the voters' demand for sovereignty?
It is possible, Your Honor. It could be a possible path to abuse, Your Honor. But when I was with the commission, we also faced that issue first in 2011, Your Honor, when then Secretary of Agrarian Reform became post-elections the number 1 nominee of the party list. And when we look at the law, we could not see any prohibition. Hence, we allowed the substitution post-elections in 2011 after the party list. And then, as the commission, we are duty-bound not to create the law, but to enforce the law. Whether or not the law, the wisdom of the law is something else, it's for Congress to amend the law, Your Honor.
You are well aware of Respondent Guanzon's participation in the approval of P3PWD's registration during her term as COMELEC Commissioner.
I would like to correct that, Your Honor. The approval of the registration of P3PWD was made by the second division, composed of Justice Inting, Justice Ko, and I forgot there's one other commissioner, Your Honor. Commissioner Guanzon, during her tenure, was never a part of the second division. What she approved, as alleged, was that as a matter of procedure, the commission, a list of all the participating party lists as approved and that will be appearing on the ballot is approved by the commission and bank. And that's what she approved, Your Honor.
So she never participated in the approval of the registration of P3PWDs.
Yes, Your Honor.
Hence, there is no conflict of interest involved when she was subsequently named as a new nominee.
None, Your Honor.
You likewise maintain the view that she never violated the code of conduct and ethical standards for public officials and employees.
Yes, Your Honor. Again, the Code of Ethical Standards or Republic Act 6713 requires financial or material interest, Your Honor. In the case at bar, the petitioner alleged that the financial interest is in the salary of a congressman, which is a very well stretch of imagination just to include it in the provision as a prohibited act.
What about Section 4AB of the Code of Conduct and Ethical Standards for Public Officials and Employees? What does it mandate?
The prohibition of 1 year upon approval.
It mandates the observance of professionalism.
Yes, Your Honor. But it is, kindly note, Your Honor, it was never Ms. Guanzon who applied for the approval. It was the party list who sought the approval of the commission. She was just a mere nominee of the commission of P3PW.
So no modicum of impropriety can be attributed to the conduct of Respondent Guanzon.
Yes, Your Honor.
Thank you, former Commissioner
Thank
Lim.
you. Thank you, Your
My
Honor.
last two questions are addressed to the Office of the Solicitor General.
Good afternoon, Your Honor.
Good afternoon, Solicitor. You are well aware of the powers and functions, constitutional powers and functions of COMELEC under Article 9C, Section 2.
Yes, Your Honor. I'm aware of the enumeration.
Have you read the powers and functions conferred by the Constitution on the Commission on Elections?
Yes, Your Honor. I
How
have.
many are there?
I don't know the exact numbers, Your Honor, but I'm fairly aware that there are more than 7.
More than 7.
Yeah, that's
So-
merely
There are
an
9.
estimation.
There are 9.
I submit, Your Honor.
Okay. Oh, which of this power or function is relevant to the case before this court?
Your Honor, I would submit that subparagraph 5 of Section 2, Article 9C of the Constitution is relevant in the sense that by
What does it state?
Your Honor, this is an express grant of power to the COMELEC to act on registrations of party lists of political parties, organizations, or coalitions.
You intransigently maintain that in this case, the COMELEC exercise its administrative functions. Where in that constitutional conferred powers can you state for such answer?
Your Honor, it is our humble submission that the COMELEC and Bank merely exercised its administrative functions. And as basis for this, Your Honor, I submit that insofar as the withdrawal and substitution filed by P3PWD, the proceedings thereof, Your Honor, merely partakes of an incident relating to matters matters concerning the registration of political parties. And in that sense, Your Honor, we maintain that the COMELEC and bank has residual power to entertain those matters even after the conduct of election.
The 1987 Constitution was drafted by these so-called constitutional commissioners. Do you know through your research regarding deliberations of the framers of the 1987 Constitution relative to this constitutional provision in question, and I refer to Article 9A, Section 7, the phrase majority of all its members, any case or matter brought before it. Do you happen to make, do you know of any deliberations of the framers of the 1987 Constitution construing, interpreting this phrase, majority of all its members? Does it mean absolute majority or relative majority?
Your Honor, I have to admit that I have not read of late the deliberations of the 1987 Constitutional Commission. However, I am aware that in the case of Estrella versus Comelec, if I'm not mistaken, Father Bernas was acting as an amicus, more or less espoused his interpretation of the same phrase and distinguished the same from how the provision is worded under Article 8 with respect to the Supreme Court, Your Honor.
Thank you. That will be all, Chief.
Thank you, Your Honor.
It being already 5 o'clock in the afternoon, we'll adjourn today's session and to resume on November 28th at 2 p.m. Clerk of Court, are there any other matters?
There are no other matters, Your Honor.
There being no other matters, the session is adjourned.